Someone you care about has been arrested. They go for their arraignment at the district court, and the judge there sets bail on their case in the amount of $10,000 cash. There's no way you could come up with that kind of money to get that person released. What can you do? Hi, I'm attorney Paul Whalen from Afford Law. At Afford Law, we practice criminal and family law throughout Massachusetts. Our fees are all set on a sliding scale, which means the less that you earn, the less you have to pay for our services. So let's take a look at a case where somebody has been, bail has been set on somebody and they are in custody. So what happens is at arraignment, the Commonwealth, that is the prosecution, can ask the judge to set bail on your case. They're saying that they don't believe that you're going to show up for court when you're supposed to show up. The court's going to look at a number of factors, including your criminal record, any history of defaults, the seriousness of the crime, and the possibility of significant punishment. What are your ties to the community? Are you a flight risk? And so forth. So after the judge does that analysis, he or she will come up with whether they will set bail, and if so, in what amount. They could release you on personal recognizance, which is still considered bail, but you don't have to pay any money to be released. Or they can set cash bail on your case. And depending on those factors that we just looked at, the judge may set bail in, who knows, $100, $1,000, $100,000, depending on all those other issues. Let's say the judge sets bail on you and you cannot raise that amount of money. So whatever it is, you cannot come up with that money. That means that you're going to be held in jail until you can come up with that money or until your case is over. And it's going to take a while for your case to be over. So if you or if somebody that you care about is in jail in lieu of bail, then they're going to be there for a while, unfortunately. But all is not lost. We can help you by filing a bail appeal. What a bail appeal is we are appealing to the Superior Court to have a different judge take a look to see if your bail could be lowered. So what happens is in Massachusetts, the courts are in a hierarchy. So district court is the first court that you go to. After that, there's a Superior Court. Then there's an appeals court. And then up top of everything is the Supreme Court, the Massachusetts Supreme Court, what they call the Supreme Judicial Court, the SJC. So we're taking the case from the district court and we're going one court higher, a court of appellate jurisdiction, to the Superior Court. And we're asking that judge to take a look at your case to please lower your bail, perhaps to personal recognizance, or at least lower it enough that you can afford that bail and you can come up with that money and then you can be released. And then we can fight your case without you being held in custody. So what happens is it takes place in the Superior Court. And the reason that is sometimes works, I think, is that the Superior Court judges see much more serious cases than do the district court cases. The criminal district court cases are serious, of course. Any criminal charge is serious. The maximum penalty that you would face in a criminal court, and I'm sorry, on a criminal charge in district court is 2.5 years. In Superior Court, they have the cases that go all the way up to life imprisonment. So they have, murder, rape, robbery, arson, trafficking drugs, all the big bad ones. So they're dealing in very, very serious cases. So when we take a case from the district court that seems like it's a pretty big deal in district court standards, we bring it up to the Superior Court. All of a sudden, the facts don't look so bad, maybe, as compared to the other cases that the judges are looking at at a daily basis. That doesn't mean that the judge is going to lower your bail, however. It just gives us an opportunity to argue to have the bail lowered. So we would argue pretty much the same thing that we would argue at a bail hearing in the district court. And the judge looks at the same factors that the district court judge looks at. But they look at it with a different eye. So the judge can lower your bail, the judge can keep the bail the same, and here's the catch, the judge can increase your bail as well. So that's something that you definitely want to be careful of. So if the judge sets bail on you and you think you can come up with that money, even though it's a lot of money, you're sometimes better off leaving it where it is and then coming up with the money, even though it's a financial burden, perhaps to your family or friends or whoever you can lean on at this time of need. Because if we go to court and you have a bail that's already set from the district court at a high level for you, but something that's possibly attainable, if we go to the Superior Court judge could blow that all up and say, I'm going to double it, triple it, whatever. And then that's something that you cannot possibly come up with. So a bail appeal has a potential downside. The judge can increase your bail as well. So my rule of thumb is if you cannot possibly make the bail that's set in the district court, you have nothing to lose really by going to the Superior Court. So let's say the judge sets a bail in the amount of $10,000 and you can't come anywhere close to raising $10,000. Then it's worthwhile to go to the Superior Court because the judge may lower it, or could keep it the same. But even if they raise it, even if they say, no, it should be 30,000. If you couldn't make the 10,000, you're going to be held anyway. If you're going to make the 30,000, you're going to still be held in the same place for the same amount of time. So there's not as much of a downside. But if you can come up with the money that the district court sets, it's advisable to do so that you can get out without causing yourself any further trouble. So that's what bail appeals are all about. Very, very important because it is having to do with your freedom. And that's something that you want to take very seriously and certainly want to consider if somebody you know is currently being held on bail out of the district court. The other thing is that even if once you go to the Superior Court, let's say you're denied and they don't change the bail, we have an opportunity at some point to readdress the bail in district court if there's been a significant change in circumstances. We can't just go back to district court and say, hey, judge, we'd like you to take a look at this bail again. We really think it's too high. That you won't even get to have the argument at that point because you need to show that there's been a significant change in circumstances just to get over the hurdle for the judge to even entertain the idea of lowering your bail. So perhaps a key witness has come forward and recanted, or whatever it might be. That would be a significant change in circumstances that could possibly warrant a judge hearing a motion to reconsider bail in the district court. So as I say, at Afford Law, we do practice criminal law and family law throughout Massachusetts. We're trying to make ourselves as affordable as possible so we can represent the hardworking people of Massachusetts. We use a sliding scale when setting our fee, which is based on your income. That means the less you make, the less you have to pay for our services. Please feel free to visit us at affordlaw.org and feel free to book a free virtual appointment with me or email me a question and I'd be happy to answer it privately. Whatever I can do to help, I'm happy to do so. Because at Afford Law, we're making justice affordable. Thank you.